Welcome to Bond University on iTunes U.
I want to begin with a very warm thank you to Patrick and his excellent colleagues for this wonderful conference and the hospitality that we've been shown. It is for me a real pleasure to be at an event which is about such a key human rights issue. And locking people up illegitimately is a key human rights issue. And it's a pleasure to be on a lovely Saturday afternoon in a room with so many human rights activists doing work that brings few material rewards and where every little bit of success is hard fought, but which is a truly heroic way to spend one's time. So I want to thank you all for that. And looking around the room, I see many people who meet that description of heroic human rights activists. And this afternoon, you can see the difference, can't you, between the last speaker and myself. He manages to pack in about 500 words a minute, but my rate is about 95, so you can slow down. I'm going to talk to you this afternoon about some human rights matters that also reflect a few battles. And I'm going to start with a little bit about my perspective, because I am not by any stretch of the imagination an academic. I have written the odd book, but technically, I'm a parliamentarian, but I'm also going to say I'm not a politician. I thought I should just say a word about this Baroness business. Because you may imagine an exotic Central European lady with a castle stretching back to the Middle Ages, but actually, it's very boring. Baroness is the title given to women who are appointed to the upper house of the UK Parliament, the equivalent of your Senate. The men in this upper house are called lords, and their wives are called ladies. So we couldn't be called ladies, could we? So we're called baronesses. That's all. There's no castle, there's no aristocratic anything. Okay, is that a letdown? I am sorry. Just ordinary. And I will also explain what crossbench means. Patrick said she's a crossbench member, and you think, what does that mean? Okay, crossbench means independent. On one side, you've got the government. On the other side, you've got the opposition. And going across are some little red benches where we sit, who are independent. No political party. Put there for some expertise or other. So this is a strange animal, the House of Lords, not elected, with a quarter of the members in no political party, but I should say packed with wisdom. We are really very much a house of elders, and we heard in the very beginning of the session this morning how important elders are, and indeed how important we are. So my perspective will be a parliamentary perspective with a bit of the rigour that comes from academia. And that may be appropriate. This subject, preventive detention, needs the input of academics, indeed, but it's also intensely political. So I'll start with a few general reflections. The use of preventive detention, and I haven't yet said what I think it is, but we'll get to that. The use of preventive detention has expanded considerably in recent years in some Western countries. I'll just say a word about the United States. This is not in any sense to be offensive to the distinguished speaker of last night or the man who preceded me. The United States has given many wonderful things to the world. Also, They've also given us 3 strikes and you're out, and a experiment in incarceration that was not really even tried by the Soviet Empire at its height. The 3 strikes and you're out is my starting point. It became famous for a man whose 3rd offence was stealing a piece of pizza. And I thought it was an urban myth. But actually it's true. There was a man who stole a piece of pizza, and since he'd already committed a serious crime, he got life. He was an African American, I'm sure that's not surprising to you, and his name was Jerry Dwayne Williams. Is this right? Yeah. Exactly. He appealed, and after 5 years he was released. So I think that's a helpful way of saying, do we have a definition of preventive detention? Well, it must be when a man is put in prison for 5 years because he grabbed a piece of pizza on a street. And that approach is very much a feature of the United States criminal justice system. An approach that basically sees criminals as enemies of society, whose acts must be punished as if there was a war against them, and whose incarceration conditions must be harsh. I've spent much of my life looking and working around criminal justice systems, and they're a very good indicator of general politics. Check whether a country sees prisoners as enemies or prisoners as citizens. And then you can place them on a continuum of how far they've gone one way or the other. And this will give you a very good indication of where they are politically on a spectrum of neoliberal authoritarian to social democratic. In the past 2 decades, we have developed this socially exclusionary ethos in criminal justice. And this helps me to bring in my second theme. That made it easier, once terrorism was perceived as a serious threat, to apply preventive detention to terrorism offences and to those deemed to present a terrorist threat. And we still have, do we not, that iconic symbol of preventive detention, the orange jumpsuited inhabitants of Guantanamo Bay, where 168 detainees are still held, I believe, completely outside the law and with no access to due process. And I want to say right at the beginning that as with many, though not all, of the human rights set out in the Universal Declaration and the International Covenant on Civil and Political Rights, there is a question of the balancing of 2 rights. The right to be punished only for what you have done, and not to be detained without a fair trial. And the right we all have to be protected by the state from violence and harm. Work I have done recently on government policies on responding to rape and sexual assault, and I must say at this point, much helped by the groundbreaking work done at Griffith University in this state by Professor Catherine Daly, who's done me the honour of appearing at this lecture, and I appreciate that very, very much, have illuminated for me the importance of seeing the state's responsibility to protect people from violent harm as an entitlement. And if anybody's interested in that idea, I commissioned for my report for the government on rape an opinion from an Oxford scholar on the human rights of victims of sexual violence and violent crime, and it's there in the back of the report. But I am not saying, and I want to say the not very strongly, not saying that one set of rights has to be sacrificed to protect another set of rights. I'm talking about how to protect both whilst preserving observance of human rights and the rule of law. And that's my theme today, to suggest ways of preserving human rights and the rule of law in the face of dangers perceived or real. And to illustrate that, I'm going to look in detail at two developments in the United Kingdom. No, not in detail. I'm going to look briefly at two developments in the United Kingdom which could be described as preventive detention. I'm going to do so for the purposes of this presentation, and the parliamentary response. And I have to say that since I've been here and listened to what's been said about Australia, it's clear to me that there are extremes of preventive detention, and that what I'm talking to you about is not at the extreme that it's possible one can describe what's happening in Australia as. And I want to also talk about the response of the courts, in the hope that these two examples will give us an idea of ways in which lines can be drawn between what's justifiable and legitimate, although not at all palatable in human rights terms, and what is not. The first I want to talk about is the government's introduction of indeterminate sentences for public protection in England and Wales, and the second is an attempt to use a form of preventive detention for those deemed to be associated with terrorism. That was the system called control orders. You also had control orders in Australia, but if I'm right, you only had two ever, and both of them have now lapsed. So a short overview I want to give you of the indeterminate sentences for public protection experiment in England and Wales. And one quick footnote, the United Kingdom is three jurisdictions: Scotland, England and Wales, and Northern Ireland. And I'm talking here about England and Wales. A government called New Labour came in 1997. Their newness was manifested by not being very Labour. One of the most noticeable ways in which they were new was their enthusiasm for long punishments and for weakening the relationship between the seriousness of the crime and the severity of the sentence. And I just want, having listened as far as I could to Chris, and I'd love to hear the speech again at the lower speed. Long sentences are not per se preventive detention, as he so rightly said. But in my view, and I'm going to suggest, there comes a point when they so become. And that's the point that should emerge from this. The new Labour government had a new approach to sentencing. And they moved away from the approach we'd had for several decades, at least 2 or 3 decades. I hope that's right, Chris. Sentencing should be in response to the seriousness of the current offence. The new Labour government wanted previous convictions to be treated as an aggravating factor. They expressed this very well in one of their explanations for the new law. Persistent offenders must know, they said, that there will be steady progress towards custody, increasing in length if they continually offend and fail to respond. This was the way they put it in 2003. Now, I remember, and Andrew will too, when the Soviet Union first fell apart in 1991, we started meeting people who came from there who were reformers. Now, they had a reform job because they were trying to reform the Gulag. the great Russian Soviet gulag that had extended right over Russia and Central Asia. They made a video. This was a very powerful little piece of propaganda. They made a video called Especially Dangerous Recidivists. We saw it. We all sat there waiting to see what this was about. It was about a prison full of elderly women, mainly toothless, bundled up against the cold, serving 10 years for theft because they had committed small thefts, they kept doing it, and the length of the sentence kept going up. Under Soviet law, committing a crime, however minor, was a crime in itself, to keep on doing it. And refusing or being unable to reform was the aggravating factor. The crime stayed the same. Each one was an aggravation towards the next level of sentence. I just say that in order to trace back the origins of this idea. New Labour picked up that Soviet idea with no shame and ran with it. And that was the beginning of a headlong rush to expand the use of imprisonment in England and Wales. When New Labour came in, the prison population was 61,500. They left their successors 85,000. So that was quite a piece of work in the time they were in power. And this idea that if you kept on doing it, or if you showed yourself to be risky and not to respond to the fact that you'd been punished, there would be a new policy. And this was called the Indeterminate Sentence for Public Protection. This required, with a small proviso, the courts to give all those sentenced for a specified offence a term marking the seriousness of that offence, but then require that these convicted persons be incarcerated indefinitely. There were 153 specified offences, ranging from manslaughter and using nuclear weapons to assisting in female circumcision and affray. The indefinite incarceration would end only when the parole board was satisfied they could be safely released, and then they would be on licence, that is, they could be recalled, for at least 10 years. This system did not produce a pizza thief with a life sentence, but it produced a prisoner given a punishment length of 28 days, because that was how serious the original offence was, that is 1 month sentence, and thereafter to remain in prison until safe to be released. And that is my basis for saying that these long indeterminate sentences could be described as preventive detention. 1 month sentence turning into life seems to fit the description. In making its decisions, the parole board decided whether a prisoner was safe to release on the basis of a report that the prisoner had successfully completed appropriate, and open quotes here, offending behaviour programs, close quotes. The fact that these programs were of dubious predictive value was not an issue. But what was an issue was that the programs were in short supply and waiting lists were long. And this led to a challenge to the courts on behalf of 2 prisoners on the basis that they were being held unlawfully. The Divisional Court looked at these cases. It decided that the Secretary of State had acted unlawfully by not providing facilities for the prisoners to allow them to demonstrate to the parole board that they were safe to release. The judge ordered one of the prisoners to be released, but he wasn't that brave, actually. He stayed execution of the judgment pending appeal. The government appealed, of course, and the Court of Appeal ruled that the Secretary of State had indeed acted unlawfully by not providing facilities, but that the detention in itself was not unlawful. And on the general question of preventive detention, the court made a useful statement, which I thought you might like to hear. case it's any use to you if you have to go to court. The court said that Article 5.1 of the European Convention, you will know what that's about, the grounds on which someone might be detained, and I quote, gives no freestanding right to detain a person on the ground that his character or personality is such that he poses a danger to his fellow men. Conviction of an offence in respect of which such detention is imposed is a prior requirement if the detention is not to infringe Article 5. So basically, the Court of Appeal said you can't do that. Meanwhile, the experiment continued. Between 2005 and 2008, the number of prisoners on this sentence went from 24 to 4,500, and the total prison population from 76,000 to 82,500. By 2008, it became clear that this experiment was not sustainable. And they brought in, rather rapidly, an amendment to restrict the eligibility to those whose actual offence merited a minimum term of at least 2 years, or those with a previous conviction for a particularly serious and violent offence. Even so, and I'm giving you these figures because I think you might not know them, and people do find them quite interesting. By 2010, England and Wales led Europe in locking up people on an indeterminate basis. These are the figures. 24 people per 100,000 of the general population in England and Wales serving a sentence indeterminate, either a life sentence or an indeterminate sentence for public protection, compared with 0.8 in France, 2.5 in Germany, 0.15 in the Netherlands, and 1.7 in Sweden. So there's something interesting going on there. The Conservative Liberal coalition government that came in 2011 brought in legislation in their first session to abolish this sentence. And it went through Parliament without much controversy, although the Labour Party, which wasn't quite as new as it used to be, but certainly hadn't decided yet that it was old, protested and said, sort of half-heartedly, we believe there's a continuing role for these sentences. But obviously the legislation was not retrospective. There's still more than 6,000 of them serving an indeterminate sentence and waiting for a parole board hearing. And I would say about this, because it's now gone, the experiment showed the benefits of having a range of energetic institutions concerned with the rule of law and prison reform ready to oppose and campaign. First of all, the courts with dedicated human rights lawyers to take the cases to court. The court case that required the government to make programs available was not as decisive as some people would have wished. They would have wished prisoners to be released. But the finding put pressure on the government. They had to provide programs. That was very expensive. The prison service was unable to cope with that pressure, and something had to be done. The independent Chief Inspector of Prisons produced quite a lot of very strong criticism, very clear criticism. We also have organisations called independent monitoring boards, groups of members of the public attached to each prison. They're very outspoken. They have a monitoring and oversight role, and they wrote from many prisons, piles of reports came in to the Home Office about the damaging effect of the measures on the running of prisons and the injustice, because these people were very concerned about justice, the injustice of there being no way out, since you had to do a program to get out, and we, the state, are not providing you with a program. A distinguished academic, some of you may know of, called Lucia Zedner, said they were one of the most pernicious of contemporary penal measures. So why did it end? And I'm quite happy to be coming here with stories of how bad things ended, because there is hope, you know, that bad things can end. It ended because of its impracticality, unaffordability. Nobody could produce an argument that had benefited society. And here's another useful quote for you. The Ministry of Justice, in its own paper, the new government's paper on how they were going to change the sentencing system, said about them, the limitations in our ability to predict future serious offending also calls into question the whole basis on which many offenders are sentenced to indeterminate sentence for public protection, and among those who are already serving these sentences, which of them are suitable for release. And I think it's quite helpful to have that officially on the record, that the government saw that the basis of these sentences was misguided. Now I will move on rapidly to look at a very different form of preventive detention. One issue is it detention at all? A form of restriction of liberty, which I think has only been tried in this form by the UK and by you in Australia. That is the control order. Imposing restrictions on the movements and living conditions of persons deemed to be involved in terrorism who cannot be taken down the criminal justice route because, well, the because is a big question mark, but the because is probably because the information that forms the basis of the decision that there's terrorist involvement, because of the way it was obtained, cannot be used in court without jeopardizing the methods used by the security agencies. That's what I assume is the because. And of course the UK is one of the few jurisdictions where intercept evidence cannot be used. Yes, that's right. You don't believe it, do you? Nor did I, but we've tried everything. I spent 4 years on the Joint Committee on Human Rights, which is a committee of both houses of the Parliament, which was set up after the passing of the Human Rights Act 1998, which brought the European Convention of Human Rights into British law. The committee had the role of holding the government to account on meeting its human rights obligations. We did this by scrutinising all proposed legislation for compatibility with the Convention and by doing thematic reviews on human rights questions. And the main issue throughout my 4 years was terrorism legislation. And during my time, we produced 18 major reports on terrorism. And the major issue out of all those reports was control orders. Now, control orders came in very quickly after what has been called a rule of law crisis. In the terrorism scare after September 2011, where many countries rushed to legislate, the government rounded up and interned, that's another way of describing preventive detention, internment, a number of suspect foreign nationals who were held in prison without charge or trial for a considerable period of time. The Supreme Court, which was then called the House of Lords, but since it's so confusing and it became the Supreme Court in 2009, I will call it the Supreme Court, held that that detention was unlawful under the Human Rights Act in that it discriminated against non-nationals. Also, holding people in detention without charge or due process would be in violation of Article 5 of the European Convention, and to be able to do it, the government would need to derogate from that article of the Convention. and the government cannot derogate unless it can establish that there's a public emergency threatening the life of the nation. But the government was convinced these people needed to be held, but the government was also, I'm glad to say, accepting it had to obey the rule of law. So they brought in new legislation, which was rushed through, establishing a new method of detaining, which was, they thought it would be lawful because it was not total deprivation of liberty. But to get it through Parliament, they conceded that it should be renewed once a year, for 1 year only, by Parliament, through a statutory instrument, without which it would fall, which would require an annual debate in both houses. And this annual review was a very important part of the way the orders evolved, because the government had to tell us exactly what was happening, and the Joint Committee on Human Rights had to do a report. Let me tell you very briefly what a control order involves. The Home Minister applied to the court for an order to be made. It was made instantly, probably within an hour, because there was a view these were very dangerous people. It was then referred to the court for judicial review. These court proceedings were very controversial, as they were normally required to be held in secret. Neither the person to be subject to the order, nor his, because they're all men, nor his legal advisors could go to the hearing. Only a security-cleared, government-appointed lawyer called a special advocate could go to the hearing. But the special advocate couldn't tell the controlled person or the lawyers what had gone on in there. Not very good. And the requirements could include, I'll reel these off, could include anything, but did include an 18-hour curfew, electronic tagging monitored twice a day by a private tagging company, a ban on the use of the garden if you had a garden, limitation on visitors and meetings to people approved in advance, allowing the police to enter the house at any time to search and remove any item, and to allow the installation of any monitoring equipment, couldn't have a telephone, mobile phone or internet access, could only move within a defined area, needed approval to send anything abroad apart from personal letters, not being allowed to go to a port or a railway station, daily reporting to the police station, having to get prior approval to study. That's for starters. It was also allowed that the person could be relocated. Relocation, called internal exile by some human rights lawyers, whereby the controllee was sent to live in another town where he had no family or contacts. And altogether 23 people were relocated under this scheme. From the day that the Act was activated, that was the day it received royal assent. It received royal assent, and 10 people were put on control orders within the same working day. It was the focus of discussion and debate and modification. The government had to agree to appoint a reviewer of anti-terrorism legislation, and from that time on, annual reports were produced about the operation of control orders. And the reviewer soon noted concerns about the effect on the person and his family, particularly in terms of mental health. So the first change was that the government set up a control order review group which monitored the impact on the mental health and well-being of the individual and the individual's family, and considered every 3 months whether the obligations should be modified. And a number of obligations were modified, like you are allowed in the garden, and you can, the police who are searching your house are not allowed to go through your wife's underwear drawers. Those sort of things gradually began to be introduced as the panic subsided. Then the court cases started. A key legal question was how preventive could this form of control become before it amounted to deprivation of liberty and was therefore in violation of Article 5. after a number of court rulings, the Supreme Court eventually decided that 18 hours curfew was deprivation of liberty, 16 hours was not. So 16 hours was the maximum that somebody could be kept indoors without it constituting deprivation of liberty. A second ruling was about how far the process by which the orders were imposed satisfied the requirements of due process and were compatible with the right to a fair hearing. The Supreme Court said that proceedings to impose a control order are not criminal proceedings, and so the right to a fair trial does not come into play. But they did say that the proceedings must be carried out in such a way that they are, in the words of the late and much lamented Lord Bingham, commensurate with the gravity of the potential consequences for the person who is to be controlled. So they therefore concluded that you have to tell the controllee something. A summary of the case against him had to be given to the person and his lawyers. The third court case was concerned with how far the government had made efforts to observe the requirement in the Act that they had to, at all times, keep the possibility of a criminal prosecution instead of a control order under review. And this, the court found that they had to take active measures to consult the police chief in the area where the person came from on a regular basis to see if there was yet enough evidence to prosecute. A disappointing court judgment for many people was when the court said that to relocate someone to another town far from where they came from was acceptable. During this whole story, 52 control orders were made, all for reasons related to Islamic terrorism, and the longest was for 4.5 years. This small number of cases and small number of people gave rise to a huge number of reports, hours of parliamentary debate, and a lot of work for the courts. This amount of attention didn't bring it to an end, but it mitigated its worst features. And it can be seen as an indication of the huge level of vigilance civil society and Parliament brought to bear on the government adhering to its human rights obligations. Now, the good news is that the current coalition government, which came into power in 2011, ended the control order regime. They brought in a similar regime, but with considerable modification. There is an overnight curfew, but not a daily curfew. There's no power to send the person to live in another town. The person can have a landline, a computer, a mobile phone, and can go to work or can study. And the Secretary of State can only impose one if she, as it is, she reasonably believes terrorist involvement rather than reasonably suspects. The length of order can only be for 1 year, renewed once. And courts will have much more involvement in making the order. This legislation will expire after 5 years, and we will get a quarterly report to Parliament. So, what can one conclude? Because I think there are some conclusions that might, just might, be of some interest to you here in Australia. Preventive detention is obviously a great temptation for governments, and it's easy to see how they end up succumbing to the temptation. And I suppose this is particularly the case for people like you and ourselves who've lived under the shadow for a long time of the terrible Murdochs. So a lot of stories can have a slightly happy ending, can't they? Right. You can see how, whenever there's a serious crime perpetrated by someone who's committed one before, newspapers will say, why was this person let out? What was the government thinking of? It's obvious this was going to happen. So it's a deceptively simple solution to look for a law that will enable you to not let them out. When dealing with terrorism, it's even more difficult because we don't know what's going on out there, because by definition it's secret. It's not easy to find a counter argument. One would prefer governments not to do this, and they should be dissuaded. But when they do it, we need a fallback. We need checks and balances. First of all, recourse to the courts must be available at every stage for everybody. And I must say that whenever the UK government has tried to restrict access to the courts, Parliament has felt that was a step too far. And our courts have played an important role in modifying, defining, gradually putting everything within a framework that makes the government need to obey the rule of law. And politicians, and I will count myself as one for that purpose, with the energetic and assiduous input of civil society organisations, have played a part. We ensured, I mean a lot of us, there is a very pro-civil liberties group in Parliament, very large. We played a part in ensuring there was regular review, provision of information by the government, taking advantage of these provisions to keep the restrictions to a minimum and discourage any expansion or net widening. We get information from the government, put it in the public domain, and then the civil society organisations can use it. It's a huge bonus to have an active and well-staffed Parliamentary Human Rights Committee. And that committee over the years has given us some guidance as to how we can keep within the rule of law. There must be time limits on all that sort of legislation. It is so important to establish that it's exceptional and the need for it should be temporary. The length of time any individual can be subject to preventive detention should be limited and the limits set in law. If the process has to be secret for reasons of national security, the minimum due process rights should be incorporated. And that means knowing the gist of the case and being legally represented. Appeal rights are essential. External oversight by an independent person is an essential element. But with all these provisos, prosecution and conviction and then lawful punishment or acquittal is always to be preferred and is, in fact, the only really acceptable route to detention if we wish to be compatible with human rights and the rule of law. And I think what we can say in the UK, and this is quite important to hang on to, that as a result of these two unprecedented experiments in preventive detention, we do not see more of it. In fact, we have less. The idea did not catch on. It has not become more acceptable. We've not been softened up for it to be extended to other groups of people who are seen as risky. It has been pulled back. Certainly, there will be a constant need for vigilance, but I hope I have brought to you a slight message that if you persevere, there is something worth winning out there. Thank you very much for listening.
For more information, visit bond.edu.au/iTunesU.